Let's now turn to our first keynote address from Professor Leigh Goodmark. Leigh is a graduate of Yale University and Stanford Law School and is currently a professor of law at the University of Maryland. She is a specialist on domestic violence, published extensively on the subject, including a recent book entitled A Troubled Marriage, Domestic Violence and the Legal System, which was released in 2012 by New York University Press and was quickly named an outstanding academic title by the Library Acquisitions Journal Choice. I heard Leigh speak in Vermont, and that was what led me to ask her if she'd be interested in coming to New Zealand. That was 9 months ago, and in the anxieties that flood you when you organise conferences, I started to hope that my memory of this woman was correct. But I heard her speak just on Tuesday, and she really is a superb communicator, as you will see. She's also that wonderful combination of scholarly, academic expert with somebody really committed to practice. She currently directs the Gender Violence Clinic in Maryland, which provides legal representation in all matters involving intimate partner violence, sexual assault, trafficking, and other cases of gender violence. Before that, she served as the co-director of the Centre on Applied Feminism at the University of Baltimore, and before that, and she doesn't look that old, but before that, she was the director of the Children and Domestic Violence Project of the American Bar Association. So welcome, Leigh, to our land. Thank you for coming, and would you please give her a welcome.
Thank you, Chris. God, I'm so much shorter than everyone else who's been up here. Chris, can you make this stay? Okay.
Right.
Can you hear me? All right. So thank you, Chris, so much. I don't actually know which one of those lovely things to thank you for the most. Sadly for me, I fear that my vanity wants to thank him most for saying that I don't look old enough to have done all those things. And thank you to the Diana Unwin Chair in Restorative Justice at Victoria University for bringing me here to speak with you today. Like many places, New Zealand is currently reevaluating its response to intimate partner violence, and my hope is to share some thoughts about the U.S. experience that might be helpful to you as you contemplate the changes that you might make. Just a bit more about my background. I've been a lawyer for people subjected to abuse for 20 years, and that's really how I see myself. I'm an academic and I write and I do all those things, but really what I do is stand in a courtroom day in and day out with people who've been abused and try to use the system as best I can to benefit them in some way. And when I started doing this work, I truly believed that the law was the best tool for addressing domestic violence. And I told Chris a story the other night that I'll share with you now. When I was 24 and just really starting to do this work, I did a divorce for a woman who'd been married for quite some time, had been a victim of domestic violence, had several children in common with her partner, and I was thrilled because I thought, this is the last legal tie between this woman and her abuser, and when I use the skills that I have to help her get out of this relationship, her life will be so much better. And I was excited about that opportunity, and I expressed that to her. And she looked at me as though I was stupid and said, I'm not happy about this. I didn't come into this relationship hoping that it would end, and I have children with this man, and this isn't what I wanted. What I wanted was to have a happy relationship. What I wanted was to have a happy marriage and for my children to have a father. And it was at that point that I really started to think a little differently about the work that we were doing, and particularly about the law's role in that work. But at that time, I thought that the legal response should be the primary response to domestic violence, and after 20 years of this practice, I don't believe that anymore. The legal system serves some people very well, but it serves other people poorly. It serves some people not at all, and it affirmatively harms some people who come to it asking for help. So to really serve people subjected to abuse, I think we need to rethink the legal response. I think we need to think beyond that response as well. So just a little bit of history about the development of the U.S. response to domestic violence. For us, the first response to domestic violence was actually civil rather than criminal, through the development of protective order law. And so you have it, so I don't need to tell you what it is. But we really came to the system first from an empowerment place, right? From the idea that women should be able to go and get protective orders for themselves without having to ask the police for help, without having to ask anyone else in a system for help, because those systems were not responsive to their needs in any way. And so looking at the ability of a woman to control what she asked a court for, without having to mediate her requests for help through other people, was seen as a very important thing to do. And those first protective orders, some of you will remember how rudimentary they were, right? They said that you had to stay away, and they said that you had to stop abusing, and they really didn't say anything else. And over time, we've developed them to be more comprehensive tools, although I think there's still lots of room for improvement. But certainly, they are more comprehensive tools than they were when we started, right? And so now in the United States, for example, in Maryland, where I practice, a protective order can give you custody of your children. It can establish visitation. It can give you a home to live in. It can give you use and possession of certain things that the couple may own in common. It can give you financial support. In the United States, we have a big emphasis now on pets and the protection of pets, because some women are reluctant to leave abusive relationships because they can't take their pets with them. We could have a conversation about that. So all of those things now can be done through protective order law, and that was really the first innovation in our system. But in 1984, the United States Attorney General's Task Force on Family Violence made a very strong statement that domestic violence was a criminal law problem that required a criminal law solution. And from 1984 on in the United States, we have seen the criminal law response to domestic violence really overtake every other potential service and every other form of response. And that was heightened. So we had laws, right, criminal laws that could have dealt with domestic violence. We had laws on assault. We had laws on homicide. All of those things could have been used to protect victims of domestic violence. They weren't being used in that way, by and large. The police response at that time was, if you have a problem, take a walk around the block. I used to think that was what we call urban myth or legend, but in fact there are training manuals from the 1960s that say to police officers, when you go to a house where there's a domestic situation, tell the guy to take a walk around the block. So this really was kind of the systemic response. It's not our problem. It's not a police matter. And so in response to that complete lack of police response, we started to change our criminal law, both substantively and procedurally. Substantively, we created specific laws on domestic violence that either said committing an assault against your intimate partner, your wife, your spouse is a crime, or that said your sentence will be longer if you commit these forbidden acts against these specific people. So those were the substantive ways in which we dealt with it. And you see still, for example, as strangulation becomes much more well known as kind of a really invidious form of domestic violence, this year in the United States there were strangulation laws being passed all over the place. So the criminal law is still being beefed up in response to domestic violence. But we also saw changes in practice, procedural changes that were, I think, much more important. One was to deal with the lack of police response. We instituted in many places what's called mandatory arrest. Mandatory arrest simply means when the police come to the scene of a crime, if they believe that crime has been committed, they will make an arrest. They do not have discretion to determine whether they should make an arrest or not. They just have to. And again, that was about the lack of response previously, and it was also about civil law judgments. So battered women throughout the United States had been bringing lawsuits against police departments for their failure to respond in ways that were protective to women who had been abused. And in one of the most notable lawsuits, a woman in Torrington, Connecticut named Tracy Thurman had called the police on numerous occasions, had never gotten an adequate police response, had called the police on a day when her husband stabbed her, and the police came and they watched him stab her and did not do anything. And they watched him take her child and drop the child on top of her, and they still didn't arrest him. And it wasn't until he then kicked her in the head, leaving her permanently paralyzed, that they made an arrest. Tracy Thurman's abuse and her subsequent verdict for $3.6 million, I think, against the city of Torrington, Connecticut, really started this sea change. And at the same time, in the United States, you had empirical work that was beginning to be done on the effectiveness of arrest. So in 1992, Lawrence Sherman came out with one of the first studies on the effectiveness of arrest, and his study said, I believe that arrest may be an effective deterrent to domestic violence, but please everybody, mandatory arrest I should say, but please everybody, don't pass mandatory arrest laws because we don't know enough yet. And in response, about 30 states passed mandatory arrest laws. And so in the United States, mandatory arrest has become very much a part of our legal landscape. For those states that don't have mandatory arrest, we have what's called preferred arrest, that you should, but you don't have to, make an arrest. And that was supported by the Violence Against Women Act, which is our huge piece of federal legislation, right, that provides funding for police, prosecutors, and courts to do the criminal justice work. So in 1994, the Violence Against Women Act passed. It starts to put hundreds of millions of dollars into communities, into specifically police, prosecutors, and courts, to do criminal justice work, but it requires initially that you have a mandatory arrest law. And so federal policy very much backing this idea that what we should be doing in every case is making arrests. Followed by changes to prosecution, because what happened after the inception of mandatory arrest was that rates of arrests went up, not surprisingly, but rates of prosecution didn't. And what prosecutors were saying was, well, we still can't make these cases because the women don't want to be part of the prosecution. And so to solve that problem, two things happened. One was something called victimless prosecution, the idea that you should be able to make a case without the victim being there in any way. You do a domestic violence case the way you do a homicide case, as though you will not have a live victim to testify. You collect evidence differently, you do your investigation differently, and that way you don't need her. So that was one thing, and probably a very good thing, right, for police to start doing and for prosecutors to start doing. But the other thing that happened in the United States was something called no-drop prosecution. And that really had to do with whether the victim wants this prosecution to happen or not, this prosecution is going forward if we can do it. And that splits off into kind of two things too, soft no-drop and hard no-drop. In soft no-drop jurisdictions, what happens is that the prosecutors make the case if they can without the victim's cooperation, and they try to get her to cooperate, they offer her services to cooperate, they make it attractive for her to cooperate, but they don't necessarily require that she be part of the prosecution. By contrast, in hard no-drop prosecution jurisdictions, what you see is that women will participate, and they will participate using any power that the state has to make them do so. So we will subpoena women to testify in court, whether they want to be a part of this prosecution or not. If they fail to comply with those subpoenas, we will arrest them and put them in jail for their failure to comply with the subpoena. We will arrest women as material witnesses, and we will put them in jail until prosecutions happen. I'm not saying this is a widespread practice, but it happens often enough that it is a problem, and it happens in my hometown of Baltimore still. We will also prosecute you for perjury should you change your earlier statement to police about what it is that happened to you, because that then undermines our prosecution. That's what hard no-drop looks like, and those are the kinds of procedural changes that we saw to the criminal law in the United States. So you would think, as the minister said earlier, that with all of this money invested, and with all of these proactive changes and this focus on criminal justice intervention, we would have made a dramatic impact on the rates of domestic violence in the United States. And in the United States, the rates of domestic violence have fallen significantly over the last, or since 1994, which is kind of what the study that I'm talking about. They've really fallen significantly. So has our overall crime rate. And so in fact, domestic violence fell at the same rate that the crime rate fell from 1994 to 2000, even though hundreds of millions of additional dollars were being put into systems to address this specific problem, right? We have the fall at the same rate. From 2000 to 2010, rates of domestic violence fell less than the overall crime rate fell, even though we were pumping hundreds of millions of dollars into the criminal justice system. There is no research in the United States that suggests that the criminal justice response is in any way responsible for that drop in the domestic violence rate in the United States. That should cause us to ask whether what we're doing is effective. So in my book, I identify 4 major problems that I see with the criminal justice response, and I just want to talk about all of those 4 problems briefly. First, and some of this is going to echo what Rachel has already said, so first, in the United States, our focus is excessively on physical violence and threats of physical violence to the exclusion of other forms of domestic violence. We ignore lots of other forms of abuse. We ignore emotional abuse. We ignore psychological abuse. We ignore economic abuse. We ignore spiritual abuse. We ignore reproductive abuse. There's really interesting research coming out now about the myriad ways that abusers are able to entrap their victims in relationships. And some of them have no relation to anything that's covered in the criminal law at all. Economic's obvious, but I think spiritual and reproductive are really interesting. So spiritual abuse refers to precluding a woman from being able to carry out the tenets of her spiritual or religious life. And the interesting research that I've seen on this comes out of the Orthodox Jewish community, where women are precluded from baking bread for the Sabbath, from carrying out their Sabbath responsibilities. And these things are so much at the core of a woman's identity. You know, when your spiritual life is at the absolute core of who you are, to deny someone the ability to take part in these activities is unbelievably abusive, much more so than an occasional slap or an occasional kick. And I'm not minimizing the impact of physical abuse, but I can tell you over the 20 years that I've done this work, my clients have said to me time and time again, it wasn't the physical abuse that was so debilitating. It was awful, and nobody likes being hit, but it was the systematic dismantling of who I was as a person that was the worst of what I experienced. It was being told that I was worthless. It was being told that I was a terrible mother. It was being excluded from family affairs. It was being minimized within as my role as a mother and as a person. It was being denied the economic wherewithal to take care of myself and to take care of my children. And so when we think about this incident-based kind of way that we talk about abuse, we should think about it not just in terms of a pattern of physical abuse that we're seeing, but all of these different kinds of abuse that we're seeing. The criminal law doesn't touch that. I think there's room to talk about whether it should. I don't personally think that necessarily we want to criminalize economic abuse. I think we criminalize in the United States anyway quite enough things. But we do need to be thinking about our inability to address all of these different forms of abuse using the criminal law. And if it's not clear, I can't overstate how completely we rely on the criminal law in the United States to do this work for us. That while people get protective orders, the salient question, even when you go to get a protective order, is, well, did you call the police? And if you haven't engaged that system, in the eyes of those who are supposed to be helping, often you are not a true victim, because you have chosen not to engage that system. So for us, I know that your protective order law is more expansive than ours, well done, in that it covers emotional or economic and that it covers emotional and psychological abuse, which makes it expansive enough to take in some of those other things. So lucky you. I wish I had that as a tool to work with. But I think for all of us, we need to be thinking about these broader categories and whether the criminal law is really the place where we want to address those things. The second critique that I make of the system is, again, something that Rachel has already touched on, in that it essentializes women who are subjected to abuse in ways that ignore the experiences of women who don't conform to victim stereotypes. So much of this work is informed by the notion of the battered woman, right, which was the title of the 1979 book by Lenore Walker that really brought, for us in the United States anyway, the idea of domestic violence into the legal system. And what Walker talked about was a woman who was meek and weak and passive and unable to respond, who was a victim of learned helplessness, who had been taught by failed help-seeking efforts that she would never be able to escape her abuser and therefore stopped trying. And so that was the victim that we offered to the legal system when we did trainings. And I say we because I was doing this work then, and I was training judges to look for Lenore Walker's cycle of violence, right? How many of us were trained on the idea of a cycle of violence that, by the way, has no empirical proof behind it? So we were training our judges, lawyers, and police to look for these indicia of domestic violence, right? To look for women who were meek and weak and passive and unable to respond appropriately, right, to the violence against them. And then other women started to show up in the system. You know, women who fought back against their abusers. And for us in the United States, the true groups of women who are most likely to have fought back against their abusers are African American women and lesbians. So when you walked into that system as an African American woman or a lesbian, and that was your experience, that was your truth, and that was the story that you told, you weren't a victim, because victims don't fight back. We also set up a system that was very much based on white, middle-class, heterosexual norms about victimization, and we did that as a political choice in the United States. So the battered women's movement in the United States has had the involvement of women of color, of lesbians, of low-income women since its inception. And those voices were largely shouted out. Because what the white women who were in charge of the movement saw was, we can't get politicians to buy into this problem if they think it's a poor people's, black people's problem. They'll only buy into this problem if they think that it will affect their mothers, their sisters, and their daughters, but of course not their wives. And so a political choice was made to cast domestic violence as something that happened to everyone, regardless of socioeconomic class, regardless of race, regardless of ethnicity, regardless of anything else. And while that's true, that it does happen to everyone, violence affects people disproportionately based on their identity. It is a very different experience to be a low-income woman who experiences domestic violence than it is to be a middle-class woman who does. In the United States, it is a very different experience to be an African-American woman and think about engaging state systems that, as Chris alluded to in Baltimore, may be more likely to shoot your partner than to do anything else useful. It is a very different experience to be a rural woman and know that the police force all knows your partner, and they all drink beer with him on a Saturday night, and it may not be such a great idea to call them. Our law ignores intersectionality. It ignores the ways that people's identities intersect and reinforce their oppression because it relies on these victim stereotypes. And so I've seen time and again when women have walked into court and said, because they didn't have lawyers, and that's a huge problem in our system, by the way, that the vast majority of women who go into court for protective orders don't have representation. And so they tell their unmediated stories without lawyers to say to them, if you say, I fought back, this judge is not going to help you because he's not going to believe you. So they say, well, of course I fought back. Well, did you think I was going to sit there and take it? But that doesn't mean that he didn't abuse me. Or, no, I'm not afraid of him, I'm just angry about what he's done to me. When you tell those kinds of stories in our system, you're not weak, and you're not meek, and you're not passive, and the system doesn't have anything for you. The third critique that I make of our system is that it's based on separation, right? So the things that we can do through the criminal justice system specifically and through the legal system generally all have to do with separating people from their partners, right? So we achieve separation through arrest, in theory. We achieve separation through prosecution and incarceration, in theory, through divorce, through protective orders. All of the kinds of things that I can provide to people in the legal system are all about separating them, or bringing people apart. So that might be fine, but I think we need to ask two questions. One, does separation actually work? And by work, I mean, does it work to stop people from being abused? And two, is it what people really want? So one, does separation actually stop domestic violence? Well, Rachel's given you the answer, but not today. In the Fatality Review report in New Zealand, one of the things that was found was that 50% of the homicides in intimate partner violence deaths in New Zealand between 2009 and 2012 took place in the context of a planned or an actual separation. So does separation work to keep people safe? It seems a dubious claim, and people have said that for years. In the United States, a woman named Martha Mahoney coined the term separation assault to describe a phenomenon of women being at greater risk of abuse at the time at which they told their partners that they no longer had absolute control over them and made their way out of a relationship, right? That creates a condition where when a partner's control of you is threatened, your risk of assault is heightened. She called that separation assault, and it just named something that our clients had been telling us had happened for years. Right? So, one, does it stop abuse? I don't think so. So the tools that we're using are not terribly effective. It also assumes something that in the United States is an increasingly dubious claim, which is that separation will actually happen through arrest or through prosecution or through incarceration. Our arrest rates are higher than they were, but what that actually means is that you're then taking into a central booking facility for processing, and you may or may be out in a matter of hours, but certainly no more than a few days. Most of the cases are charged as misdemeanors, which means that you're not going to be held for long, that bail is either going to be on your own recognizance or very low, and that the ultimate penalty for that crime is not usually more than 6 months incarceration, and that you're not going to do 6 months incarceration, right? You're going to do no time, you're going to be on probation, but the sentences are very, very short. So again, does it work? Well, it might if we actually did any of those things, but we don't. And so it's hard to see that the criminal justice system separation actually works. The other question is, do people want it? And as in that example I gave you earlier, I think people are very ambivalent about separation. There's a range of responses. I have clients who never want to see their partners again. They very much want separation. It's all they want, and that is great. That's the person I can help. That's where I can use the legal system effectively on someone's behalf. But I also have clients who really don't want their relationships to end. They just don't want to get abused anymore. And the legal system has absolutely nothing to offer those people. And in fact, not only do we have nothing to offer those people, we've chosen to ignore love as something that our clients experience at all, because it's too difficult a concept for us to grapple with. We're uncomfortable with it. And so in the literature, rather than talking about how people love their partners, and it's not surprising that people love their partners, very few people enter a relationship on day one and start being abused on day two. Oftentimes, there is a development of emotional bonding and trust and love in these relationships before abuse starts. And people are able to look at their partner not just as an abusive person, but as somebody with whom they have a history and a past and a family into which they've invested tremendously and which they don't really want to turn their backs on immediately. We've ignored that. We haven't talked about the value of love. We're uncomfortable with the idea that a woman can love her abusive partner. And we don't know how to deal with that. So in the literature, you see it called traumatic bonding. She doesn't really love him, but she's experiencing something akin to Stockholm Syndrome, right, in which she is traumatically bonded to her abuser. I think that does a grave disservice to our clients. I think it's unfair to them. And every time we have that response that says, well, you need to separate, we're creating a condition in which our client may feel uncomfortable telling us, but this is a relationship that I value. So in addition to all of the reasons that we already know about why people don't separate from their partners, right? And because we could do the DV 101 training, we could say it's economics, it's children, it's religion, it's immigration status, it's community status, it's all of these, it's housing, it's transportation, it's work, it's all of those other things. In addition, we should be talking about love. And when we're talking about love, we have to recognize then we don't really want to talk about separation. We want to talk about how we can make relationships places where people can be safe and validated. The fourth critique that I have of the US system is one that I really hope that you'll think about as you think about changes to your law. And it's the one that tends to get me in the most trouble in the United States. I am very opposed to the mandatory policies that we've created. Mandatory arrest and no-drop prosecution. I think they're incredibly problematic in that they assume that the state is best placed to intervene on a woman's behalf whether she wants it or not. These are the most intimate relationships in people's lives. In terms of who should be making decisions about what should happen in those relationships, I firmly believe that it is not the state's role to make those decisions about what should happen to that relationship. It is the woman's place to make decisions about what should happen in that relationship. Now, the argument to that is this. Women are so coercively controlled by their partners that they cannot make free, conscious choices about what they want in their relationships, and it's in those instances that it's important for the state to step in and to protect her when she can't make a good choice about protecting herself. Okay. I will tell you that over 20 years, the number of women who I've had you alluded to Evan Stark, who's a friend, and Evan writes about women who are completely coercively controlled. But coercive control is really a spectrum. And there are some people who are incredibly coercively controlled, and there are some people who are not, right? And we have to look across that spectrum, and we have to decide where we want decision-making based. Do we want it based on the people who are the most coercively controlled and unable to make decisions for themselves, which I gotta tell you is not the majority of the clients that I have seen over the 20 years that I've done this work? Or do we want to make decisions towards the other end of the spectrum and assume that even in conditions of constraint, women can make choices for themselves? We all make choices under conditions of constraint. None of us has free choice. If you had free choice, that would mean you would have all the money in the world to effectuate any choice you ever wanted to make. I doubt that any of us does, given what we do. All of us make choices in conditions of constraint. The constraints that women subjected to abuse face are very different kinds of constraints, but we all make choices in that way. We can improve the information we can provide. We can improve the support that we provide. But taking choice away from people, I think, is just a terrible, terrible idea. And there is no evidence that mandatory policies decrease recidivism or that they keep women safer. And I guess I just want to say a word about safety. So in the early battered women's movement, the two goals, the kind of the twin goals of the battered women's movement in the United States were safety and accountability. We got to keep women safe. We got to hold men accountable for their behavior. And it seems to me an assumption's been made about what safety means. Safety is not just physical safety. Safety means lots of things to the women that I work with. Safety might mean emotional safety. Safety might mean financial safety. Safety might mean physical safety, and it might change over time. But to assume that every woman's highest goal is physical safety is to ignore, again, these range of behaviors that we call abuse, because the physical abuse may not be the worst thing that she's experiencing. And to make our interventions responsive only to that form of safety is deeply problematic. And that goes back to why mandatory policies are so problematic for me, because they assume that physical safety is paramount in every situation. And while in the cases that Rachel talks about, when you look at fatality review, certainly physical safety was paramount in those cases. But that's not necessarily the norm that everyone is experiencing. And so I think our system needs to be responsive to that range of experiences that women are having. One could argue that we don't know whether mandatory policies are truly effective because they've never actually been fully implemented in the United States. And I think that's a fair argument. Even in places where there is mandatory arrest in place, police still don't make arrests. They're still not as responsive as they might be. The prosecutions still don't necessarily go forward. So it's fair to make that argument, I think. And my response to that is we're never going to know that, because no system is ever going to work perfectly. But after Sherman's 1992 study on mandatory arrest, there have been a number of attempts to replicate his research, and no one's ever been able to do it. No one has ever found that mandatory arrest necessarily makes women safer. At best, there's been a modest effect that may be explained by other kinds of things. At worst, there is some evidence that it makes women less safe in certain communities. And so in the United States, we really jumped the gun in terms of creating policy based on scant social science evidence coupled with large liability, which was really the driving force behind that. I think the denial of autonomy and agency to women who've been abused puts us in the exact same shoes as her abuser. That when we decide that we are the ones who should be making decisions about her safety and about how she should proceed in her relationship, we are exactly the same. Although our goals are different, and although our motivation is different, we are doing the exact same thing that her abuser has been doing to her, and I think that is deeply, deeply problematic. So let me be clear about something, because frequently people think that what I'm then going to say is, so we should get rid of the criminal justice response altogether. And that's something that people in the United States are thinking about, is decriminalization in some ways. And it's a really interesting and really difficult conversation. I've told Chris I'm just at the very beginning phases of thinking about and writing about this issue, because there are people who make these critiques of the criminal justice system, myself among them, and then kind of go, and therefore the criminal justice system is bad. And what follows from that could be, and therefore we shouldn't have criminal justice intervention. I don't think that's true. And for me, the touchstone is always, what is it that my client wants? If my client wants punishment through the criminal justice system, if she believes that that is the system that will keep her safe, I want that system to work for her. But for all of my clients who want nothing to do with that system, I want there to be options for them as well. So, what would a reconstructed legal system look like? I think a reconstructed legal system, much as Rachel has said, would be a system in which women had information. That there weren't assumptions being made about what they should do, and they weren't being told what they had to do. They were being told what their options were in ways that made them able to make thoughtful, considered choices for themselves, right? So what might that look like? So you are abused and you call the police and the police come. And what does that conversation look like when the police arrive at your door? In the United States right now, it looks like, ma'am, we got a call. We have probable cause to believe that there's been an act of domestic violence and we're arresting your partner. See ya. But what that conversation could look like is, ma'am, we got a call. We're going to separate the two of you and have a conversation. And in that conversation, we're going to talk about what it is that's happened to you, what that pattern of abuse has looked like, whether you've used the police before, what the police response has been, because the single greatest indicator of whether a woman will even call the police is what her previous experience with the police has been. And when that experience is bad, they don't call again. So you have that conversation to say, here are the options that are available to you. We can make an arrest, and he doesn't need to know that you wanted us to make an arrest. We can just make that arrest. And if we make an arrest, he will be taken to this kind of central booking facility, and he will be there for however long that takes in your jurisdiction. For us, it's hours. For other places, it's days. And he'll be held for this long. And does that give you enough time to get your things together and to get to some place where you feel that you might be safe? And do you have resources that will enable you to do that? And are your children somewhere that you can pick them up and get them and go? Or do you need to stay in this place? And will arrest make you less safe? And if he's arrested, he'll be referred for prosecution. And here's what prosecution looks like for us. It means that he's likely to be prosecuted with second-degree assault, which is a misdemeanor in our jurisdiction. And oftentimes, people are given probation for that. Is that going to make you less safe or more safe in the ways that matter to you? Will prosecution help you? Will the threat of prosecution make him change? Do you think that he is likely to be deterred by the idea that there is a prosecution pending, right? For some people, prosecution is a powerful deterrent. For other people, they could care less. But she's the one who knows whether that's going to be a good deterrent for her or not. And yes, that's a much more involved conversation than people are having now with police officers. And yes, that puts a tremendous amount of responsibility on police to do things that they haven't been trained to do up till now. But I think that that's a better way to do things. I think that that's a better system. And it gives people the ability to make thoughtful choices about how they want to proceed. Similarly, when cases are referred for prosecution in the United States, you become a witness, not a party. And as a witness, you have very few rights as to how that case goes forward. But at least you should have the right to consultation with the prosecutor. And you should have the ability to have the prosecutor have a conversation with you that, again, goes like this. We are likely to prosecute him for second-degree assault. The sentence that we often get for second-degree assault is probation. At most, the sentence will be 6 months jail time. At least, he'll be found not guilty. He'll be acquitted. How will that affect you? If the prosecution goes forward, you will have to testify. Here's what we'll expect you to testify to. You will have to be cross-examined. Here is what cross-examination feels like. Here's what they can ask you about. Are you going to be okay with that? Are there resources that you need to make you better able to take part in this prosecution? If we gave you some economic support, if we helped you with childcare, are those things that might help you get through this prosecution successfully? And having that conversation, again, could enable somebody to make a thoughtful choice about whether prosecution is something that is likely to meet their goals, whatever those goals might be, right? Whatever safety looks like for them in that moment. And then we get to restorative justice. And because I'm talking about restorative justice this afternoon, I don't really want to talk much about it now. You guys are going to be so sick of me. But just to say that restorative justice can be an important part of a state-based system, right? There are two ways to think about restorative justice, I think, in the context of intimate partner violence. One is as part of a state-based response, but the other is outside of a state-based system. And so I want to think a little bit more for now kind of about that outside of the state-based system. Because there are many people who, for whatever reason, are not interested in engaging the state. And marginalized communities in the United States particularly, given the history of racism and police brutality and maltreatment by the state, have real reasons not to be engaged with those systems. I haven't even talked about child protection, but if you are a mother in the United States and you go to court and you say, and my children were in the room at the time that this happened, you expose yourself to child welfare liability that can be devastating. And I have had clients try to get protection to protect their children. And not only were they denied protection, they were then brought into the ambit of child welfare. Devastating. So lots of good reasons why people don't want to engage with the system. So for those people, I want there to be options as well. I think restorative justice is a wonderful option when it's done right. And that's not easy. And I think that's something Rachel alluded to, and I agree with her. I have to tell you that the restorative justice standards here that you've done in family violence cases are wonderful. There's such a rich starting point for a great conversation about how to do this work properly. And I think you're so lucky to have that as a tool. It's something that we've looked at in the US as we've started to have this conversation as well. And you can do that kind of work through conferencing, but you can do it through victim offender mediation. You can do it through community accountability programs. There are lots of ways to think about justice. One thing we have not done is to actually ask women subjected to abuse, what would justice look like for you? Is it retributive justice? Is it punishment that we can get through the criminal justice system? Or is it something very different? And if it's something very different, how do we help you meet your justice goals? And I think restorative justice is a way that we can do that. We haven't talked about economic stability, though it's one of the structural factors that I think Rachel alluded to earlier. In the United States, there's research that suggests that low-income women are most likely to be abused, and that men who are unstable in their work are most likely to be abusive. So it seems to me, rather than continuing to put money into the criminal justice system, we might do a great bit of good by helping men find jobs, and that we might decrease domestic violence significantly by finding economic stability for both men and women. It's a cyclical effect that's incredibly problematic, right? When we send people to jail in the United States and they come out, guess what they can't get? Jobs, because nobody wants to hire somebody who's been in jail, which makes them more economically unstable, which makes them more likely to be abusive. And it creates deterioration within neighborhoods, and there's social science evidence, again, in the United States to suggest that in deteriorating neighborhoods, domestic violence is more prevalent. So we get this cycle going that's so problematic, and it's criminal justice that really drives that cycle. Engaging men. We talk about men who abuse as though they were demons. We talk about them as though they were devils. We do not treat them with humanity. We do not treat them with dignity, largely within our state systems. Men's abuse of women can only be stopped if men stop abusing women. It's not about what women do. It's about men making change, and men making change in their lives. And we don't give men any good reason to make change in their lives, and we don't really give them the tools for doing it. Abuser intervention programs have terrible track record in the United States. The social science evidence on them is not good, but we've seen some pockets of places where men will change. Men change around cultural responses. Men change in response to the impact on their children. And we need to really think about why it is that men are abusive, rather than making assumptions about why men are abusive. We have assumed for a long time that it's about power and control, but we've never really delved into that with men to determine whether that's what motivates them. Until we understand what motivates men, we won't make change. Until we make change, we're not going to make an effect on this problem. So just to sum up, or to stop, because I know I'm running out of time and I'm cognizant, we also need to be focused on the larger structural forces that create and contribute to intimate partner abuse. For us in the United States, that's economics, that's housing, that's racism. We need to think about prevention. We need to think about front-end responses. And the fair critique of everything I've said is, how are you going to do all of that? It's impossible, right? And it's true. It's a big challenge. But I think for those of us who truly care about this problem and have seen, as the minister noted, we are not making a dent doing what we're doing now. We have to be willing to try something new. We have to be willing to challenge the things that we've been doing for years and years. But we are not going to prosecute and incarcerate ourselves out of this problem. In the United States, in 2009 to 2010, there were 907,000 acts of intimate partner violence. We have 2.2 million people in jail already. If we prosecuted all of those folks, and our current prosecution rates are about 64% with arrest, 27% when there's no arrest, if we prosecuted all 907,000 of those people and all of those cases resulted in conviction and incarceration, we would add significantly to what is already the largest incarcerated population in the world. We would exacerbate all of the effects that we're already seeing in terms of the criminogenic effects of incarceration. We are not going to do good through greater incarceration. And these are men who are then going to come out of brutal state systems, having learned only to be better criminals, and bring that home to their families. That is not going to work. So the time has really come to face our fears about what it is that we're trying to change, and to think creatively about how to make that change. And I look forward to talking with all of you about how to do that.